All right. With apologies for the very, very delayed start because of technical issues this evening. On behalf of Law for Palestine and Jadaliyya, I would like to welcome everyone to the conversation on turning ink into action, unpacking the ICJ advisory opinion and the next steps with our distinguished speakers this evening. Today's conversation will take place in English and live interpretation is available. We request you to kindly post your questions in the chat as we move along, and my colleagues will gather them so we can get to them in the second half. On the 19th of July, the International Court of Justice rendered its advisory opinion on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. Against the backdrop of over 76 years of settler colonialism and ongoing Nakba, the opinion comes at a time when we find ourselves 10 months into the genocidal assault on the Palestinian people in Gaza. This opinion was a result of the request made by the UNGA in December 2022 and addresses the questions: what are the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement, and annexation of the Palestinian territory? And how do the policies and practices of Israel affect the legal status of the occupation? And what are the consequences that come from this legal situation for the states and for United Nations? The advisory opinion is significant in that it states that the continued presence of Israel in the occupied Palestinian territory is unlawful and needs to come to an end as rapidly as possible. The court also considered that the policies and practices of Israel amount to annexation of large parts of the occupied Palestinian territory, including the construction of settlements, are contrary to the prohibition of the use of force and the principle of non-acquisition of territory by force. The court also touches on the legal questions of apartheid and outlines the consequences for Israel, the UN, and the third states. We meet this afternoon with our distinguished panel to understand what the significance of this advisory opinion is, its legal consequences, and how can we tangibly leverage it at different levels to pave the way forward for Palestinian self-determination. To help us comprehend this advisory opinion, we have an excellent group of speakers today. We have Professor Ardi Imseis. Dr. Imseis is an associate professor of law at Queen's University, Canada. He has worked at the UNRWA and the UNHCR and is an author of The United Nations and the Question of Palestine, Rule by Law and the Structure of International Legal Subalternity. He has served as a legal counsel on several cases before the ICJ, including the one we're talking about. Professor Ardi, the floor is yours.
Thanks so very much for having me, Anisha, and to all friends at Law for Palestine. It's a pleasure to be with you. In short, the advisory opinion of 19 July is a groundbreaking moment. I don't use that word loosely. It introduces a paradigm shift in the international law on Israel-Palestine that will have, I hope, consequences and reverberations for years to come. As you've mentioned in your lead up now, the court has been asked a series of questions and it answered them as follows. Owing to the violation by Israel of a series of international humanitarian, international human rights, and general principles of international law, the court has determined that Israel's very presence in the occupied Palestinian territory is unlawful. For many of you listening, many of your listeners, that might not strike anyone as new or fresh. Many people might also be under the misapprehension that all occupations are unlawful, but that isn't so. The United Nations has spent decades documenting chapter and verse the violation by Israel, the occupying power, of a litany of individual discrete violations of international humanitarian law and human rights law in its time in the occupied Palestinian territory, among which settlements are unlawful, deportation of a civilian population unlawful, torture unlawful, all manner of things. But the International Court of Justice has yet, or at least until Friday, last Friday the 19th, some 2 Fridays ago, to determine that the regime giving rise to all of these violations is itself unlawful. And this is why it is important that they found that Israel's presence in the territory is unlawful. It is important because that gives rise to legal consequences under international law that are very clear and also which will have legal and political impact going forward. The first obligation on Israel is to end its occupation of the occupied Palestinian territory as, quote, rapidly as possible. This is an obligation that is a unilateral one and is unconditional. Very important because for many, many decades now, the international community almost universally has told the Palestinian people that the only way the occupation is ever going to come to an end is through negotiation. Of course, that would strike one as odd because however do you negotiate the end of the occupation with an occupying power that is acting in bad faith? By settling the territory, by claiming to have annexed portions of it or all of it, by insisting that only its people, the occupying powers people, are sovereign in it, and so on. It's wishful thinking to suggest that any of that could be brought to an end through negotiation. And of course, international law is very clear, thankfully, can provide clarity to this problem, because now that the occupation has been declared definitively by the court to be unlawful, to be an internationally wrongful act, its end, as I said earlier, must happen unconditionally and as rapidly as possible. That is to say, not be subject to any form of negotiation. The only thing that should be discussed is the modalities of bringing this illegal situation to an end, and to do so as rapidly as possible, which I'll get to in a moment further. In addition, the Israelis have an obligation to make reparations. It's been affirmed by the International Court of Justice for the damage to natural or legal persons brought about by virtue of its illegal presence in the occupied Palestinian territory. Now, that is all technical language, but consider the breadth and scope of that. Reparations include everything from restitution of property, return of refugees from 1967 territories and so on to the territory. And that property would be movable and immovable, very, very broad restitution of persons in the position they would have been in, but for the illegal action in the first place. And where restitution is not materially possible, the obligation under international law of state responsibility is to make appropriate forms of compensation. Imagine generations worth of damage brought to bear by the occupation on people in the occupied Palestinian territory. All of that would need to be calculated, verified, etc. It's a lot of work, but at the same time, the scope is very, very broad. I imagine in the hundreds of billions of dollars worth of compensation over generations. In addition, then you have other principles of satisfaction and so on. So Israel must make appropriate forms of reparation for its illegal presence in the territory that flow from the initial finding of their being there in violation of basic principles of international law, the right of peoples to self-determination and their violation of that, and the general prohibition on the acquisition of territory through threat or use of force. In addition, the court found, as you rightly mentioned, that Israel's very presence, its regime in the occupied Palestinian territory is violative of Israel's obligations under Article 3 of the Convention on the Elimination of All Forms of Racial Discrimination, which imposes a prohibition on all signatory states to that convention of the imposition of regimes of racial segregation and apartheid. The court wasn't as clear on the question of apartheid in its majority opinions, but you get some minority opinions and other such, which we'll hear about, I'm sure, from Michael later on. The point is, up until the 19th of July, there were open questions in mainstream circles as to whether or not Israel had imposed on the Palestinian people and the OPT a regime of racial discrimination or segregation and or apartheid. Those have now been laid to rest by the principal judicial organ of the UN. And now the question is going to be, what does all that mean for Israel? We know what it means. It must end its presence, but also for third states. So let me focus on what the consequences are for third states of this opinion in broad terms, and then we can go in depth later on. The court reaffirms the basic principles of international state responsibility in this opinion. And they are as follows in respect of third states. And it's because, before I get to them, because Israel's occupation is violative of serious or introduces serious breaches of peremptory norms, derogation from which is not permitted. It's a term of art. And norms, the character of which are erga omnes, that involves or triggers third state responsibilities as follows. First, third states are under an obligation not to recognize the legality of Israel's continued presence in the territory, in the whole of the occupied territory, which of course encompasses the West Bank, East Jerusalem, and the Gaza Strip. Second, the third states are under an obligation, forgive me, to do nothing to aid or indeed assist the continued presence of Israel in the occupied Palestinian territory. And so the scope of the duty of non-recognition and non-aiding or assisting is very, very broad, because one can imagine that we're not now talking about discrete individual violations of the laws of war or human rights law by the occupying power. The illegal act is the occupying power's very presence in the territory. It is there as an aggressor. And so that will affect bilateral relations between Israel and third states, because those third states they're now under an international legal obligation to review their bilateral relations with Israel: economic, military, political, social, diplomatic, cultural, and so on. And if it can be said that any of these states' bilateral relations, any policy that they have vis-a-vis Israel, is connected to Israel's continued presence in the occupied territory, then those third states would have an obligation to rectify that. So arms trade is very, very clearly now on the table. The IDF, the Israel Defense Force, and Israel's military industrial complex has used the occupied Palestinian territory for generations as a training ground for its troops and also for its military technologies. And then they would be sold to the world as battle tested, so to speak. All of that has to come to an end by virtue of what the court declared on the 19th of July as third states' obligations not to aid or assist Israel in its continued illegal presence in the occupied Palestinian territory. And finally, the court also made indications of what the obligations are for the United Nations, and said very clearly that it is for the United Nations General Assembly in particular, but also the Security Council, to determine the modalities of how Israel's presence in the occupied Palestinian territory is to be given effect as rapidly as possible. The end of that presence is to be given effect as rapidly as possible. And I'm sure we'll hear more from Michael on what the General Assembly will do, but the next move is to go to the GA, and there will be a resolution adopted there. There are some cases precedents that exist. The Chagos Islands case in particular, which I will refrain from commenting on unless it comes up later on. But all this to say that in terms of how the opinion has been received so far in the week and a half or so since its issuance, it appears to me that interlocutors on the international plane, including I should say at the United Nations, still have yet to appreciate the importance and the weight of this opinion and what it requires under international law in terms of responses from all states, including Israel, but also third states and the United Nations. And it will take some time for that work, for that appreciation to evolve and develop. But I suspect that right now there are many international lawyers in the foreign ministries of many a country who are reviewing that opinion very carefully with a view to ascertaining what it means for the international community of states and the United Nations. And once they do and complete their review, you'll see that the way will be made open very clearly for fundamental changes in how Israel, now a racial segregationist and apartheid state in occupied Palestine, is handled on the international plane. not a small moment, a big moment, and looking forward to seeing how things evolve.
Thank you so much for that comprehensive overview. And I think there are already a whole bunch of topics that I think we're going to go back to once we come back to you on that. So thank you so much. Our next speaker is Professor Michael Lynk, who is an associate professor at the Faculty of Law at Western University, Canada. Michael Lynk was a special rapporteur on the situation of human rights in the occupied Palestinian territory, and his report to the General Assembly was significant in initiating the conversation that has brought us to this advisory opinion today. Michael will talk to us about the role of the General Assembly in light of the advisory opinion. What are the expected steps forward, and how do we understand this in the UN context? Michael, the floor is all yours.
Anisha, thank you very much for inviting me, and thank you to all of our friends at Law for Palestine for their indispensable work on pushing international law to maintain a strong spotlight on the situation in Palestine. It's always an honor to be asked to speak to Law for Palestine. I'm going to speak briefly about the role of the General Assembly with respect to this. I'm also going to speak a little bit about apartheid and what the court said with regards to that. As the two of you have already mentioned, this advisory opinion arose from a resolution adopted by the General Assembly back at the end of December 2022, where it asked for an advisory opinion coming from the International Court of Justice with respect to, as Ardi said, essentially asking whether the prolonged occupation that had been conducted by Israel since 1967 has crossed the bright red line into illegality. And let's keep in mind what an advisory opinion is as we go through what the role of the UNGA is. An advisory opinion fulfills one of the two basic judicial duties of the International Court of Justice, which is the highest court in the United Nations system. The court has its first responsibility is to adjudicate disputes between countries, and we saw that with respect to the application brought at the end of December of 2023 by South Africa under the Genocide Convention against Israel, where the argument was that Israel was committing genocide, a breach of the Genocide Convention and the Rome Statute with respect to its conduct of the war in Gaza. And the provisional measures, if you like, injunctions that the court has issued in January, March, and May of this year against Israel are meant to be legally binding directions and orders by the court towards Israel. Alas, only really the Security Council has the authority to be able to put those into place, and we know what the role of the United States as a permanent member and its veto has meant. The second responsibility of the International Court of Justice is to provide answers to requests for advisory opinions coming from competent bodies within the United Nations system and the broader international system. And these advisory opinions are the court's, if you like, studied opinion after hearing full argument on facts and law on a particular issue. These are non-binding, but because of the reputation, the high reputation of the court, they have considerable authority and impact upon international law. So the court issued its advisory opinion 10 days ago on the 19th of July. This now goes back to the General Assembly, which had requested the advisory opinion, and it's now up to the General Assembly to adopt, I guess, its response to the advisory opinion. And this will doubtlessly come in the form of a resolution to be introduced sometime in the autumn at the General Assembly's fall session. That will probably do two things. One, it will doubtlessly accept and endorse the advisory opinion, and second of all, it will the General Assembly then will probably come up with directions for the United Nations and directions for the international community on how to apply the advisory opinion with respect to Israel. This is going to present, I think, probably another fault line between the global North and the global South at the General Assembly. On the one hand, we saw a number of virtually all the countries and states that argued, and organizations that argued from the global south at the advisory opinions arguments before the court over 6 days in February 2024 were on side with asking the court for a robust answer to the advisory opinion. And while many of the countries coming from the global north either were asking the court not to make a decision at all, we saw that from the United Kingdom, we saw that from the United States, we saw that from Canada, or it was asking for, I guess, a very low-key opinion from the court, which it didn't provide. It luckily did provide this robust response to the request for the advisory opinion. Well, now we do have initial comments made by the European Union's representative on foreign affairs, who said, I believe, on Friday that he welcomed the advisory opinion coming from the court. And if I can quote, he said, "The court's advisory opinion provides a valuable guide for the players in the international community. Never before," he said, "has the gap between law and the reality on the ground been so wide, and all under the watchful eye of a powerless international community." Well, here's the opportunity for the international community, more specifically the global north, to make up for that powerlessness that it has so deliberately exercised over the years of passing resolutions and never expecting them to be applied with respect to Israel and its role in the occupied Palestinian territory. So I think we were probably going to see a robust debate with the global south primarily asking for a range of measures to be exercised against Israel if it doesn't act in good faith to start the steps to withdraw completely, as the court said, and as rapidly as possible from the occupied Palestinian territory. We, of course, have every indication that the opposite is going to happen. The day before the advisory opinion was released on the 18th of July, the Israeli Knesset passed a resolution overwhelmingly saying that that the Knesset opposed a Palestinian state in the heart of, it said, in the heart of Israel. And every party either didn't show up for the vote or it voted in favor of the resolution, except for those predominantly Palestinian Arab parties sitting in the Knesset. And then in the immediate aftermath of the release of the opinion on the 19th of July, the Prime Minister of Israel, Benjamin Netanyahu, called the decision, as you said, absurd. And it has obviously no intention of complying. We know that the United States has said that the decision is unhelpful and is only going to drive the parties further apart. So we can't expect anything positive coming from the United States with respect to exercising pressure on Israel. If we look back 20 years, we know that the UN General Assembly passed a comprehensive resolution in the aftermath of the advisory opinion coming from the court with respect to the construction by Israel of a wall in the occupied Palestinian territory, where it accepted the decision or the advisory opinion. It asked member states to comply with the directions in there, and in particular, it set up a registry to measure damages. That all became a dead letter because the General Assembly specifically and the United Nations more generally never followed up with action. And in fact, as we know, that wall not only exists today in spite of the ruling from 20 years ago, but it continues to be built. Will the same thing happen with respect to the resolution from the General Assembly probably accepting the advisory opinion? Time will tell, but I think the mood of the world has changed considerably in the past 20 years. We recognize the comprehensiveness of the advisory opinion coming from the court. We recognize the dire strait of the Palestinians, particularly with respect to the conduct of Israel's military war on Gaza over the last 9.5 months, and that the world, I think, is in a stronger position, particularly some countries in the global north, in wanting to take action with respect to Israel. If I can just leave it there, and just briefly address the question of apartheid and how the International Court of Justice addressed that issue. We know that
Michael, I wonder if it might do good for me to just comment on the GA before you enter into apartheid questions. Would you mind terribly?
Go ahead.
Yeah. One of the things that we should be looking out for is, as I've mentioned earlier, the precedent that were set by the General Assembly when it received the opinion in the Chagos Islands case. So in 2019, the advisory opinion, rather the International Court of Justice was asked for its advisory opinion on whether or not the United Kingdom legally decolonized the Chagos Islands, Mauritius, in 1965, and the court determined that it did not. That when it granted Mauritius its independence from British rule, it acted illegally in maintaining a continued presence and administration over a portion of Mauritius, being the Chagos archipelago in the Chagos Islands. And therefore, the court ruled that the United Kingdom's continued presence in the Chagos Islands needs to end, quote, as rapidly as possible, which is the same standard that it used in respect of Israel's obligation to withdraw as rapidly as possible. Well, we get a window, if we might sort of have a look at the window of the thinking of the General Assembly on what they perceive to be the meaning of as rapidly as possible. Of course, this would have to be taken on case-by-case basis. It might mean something different in Israel-Palestine. But in Chagos, when the General Assembly received the opinion, it set a 6-month deadline for the end of the United Kingdom's continued administration of the Chagos Islands. So one of the things that we may see from the General Assembly looking forward is the fixing of a specific date by which Israel is required to end its occupation of the OPT. And then, of course, that would trigger consequences that could be very broad once Israel does not do that. And there's every indication that they won't. And in addition, one last thing on the advisory opinion's legal binding character, if you like. Yes, informally, it's not binding because it is advisory after all. But its binding character, the binding character of the principles that are set out there, doesn't only rest on the good reputation of the court. It rests primarily on the fact that the principles adjudicated upon by the court, and uniquely so because they are mandated to interpret and apply international law generally in the world, are all already binding. These principles are customary international law, binding on all states. And this case is based on not only binding custom, but also principles that have a character of erga omnes and also peremptory principles, derogation from which is not permitted. So insofar as the court discharges this function as the primary adjudicator, if you like, of general principles of international law, and does so in affirming principles that are already binding on the international community, all of those things are absolutely binding as a matter of general international law. So I just want to leave no doubt among the listeners that this advisory opinion is, its substance is itself binding on the international community. I'll stop there, and thank you very much, Michael, for letting me interrupt you on the GA.
If I can just make a few comments with respect to apartheid. Let's recall that in its advisory opinion request back in December 2022, the International Court of Justice was asked by the General Assembly to comment on whether or not, as part of its answer to is the occupation still lawful, as to the role of Israel's discriminatory legislation as it impacts the occupied Palestinian territory. And this has led the court to provide actually a very cautious comment with respect to apartheid. And I say cautious because apartheid is only mentioned 3 times specifically in a 83-page ruling. And this probably shows that almost more than any other issue, this required the court the judges to enter into a range of compromise discussions over how to deal with this. But my bottom line interpretation is that the court has said there is apartheid being practiced by Israel, the occupying power, in the occupied Palestinian territory. Keep in mind that the court, in examining the issue of discriminatory legislation, it spent 49 paragraphs of its decision, which is the longest single section of the entire 80-page ruling, devoted to the issue of Israel's discriminatory legislation and measures in the occupied Palestinian territory. It said, this is what the court said, it said this regime of comprehensive restrictive restrictions imposed by Israel constitutes systemic discrimination based on race, religion, or ethnic origin in violation of the two 1966 covenants on human rights, as well as the International Covenant on the Elimination of All Forms of Racial Discrimination, which is called CERD. And this is an important recognition by the court. The court then went on to quote in full Article 3 of CERD, the Convention on the Elimination of Racial Discrimination, which says that state parties particularly condemn racial segregation and apartheid and undertake to prevent, prohibit, and eradicate all policies of this nature in territories under their jurisdiction. And immediately after quoting from Article 3 of CERD, the court went on to say that this article refers to two particularly severe forms of racial discrimination, racial segregation, and apartheid, unquote. The court then provided, I think, a range of very rich evidence that went to two essential aspects of how Israel's policies and practices of racial segregation and apartheid are being performed in the occupied Palestinian territory. It talked about the physical fragmentation of both East Jerusalem and the West Bank. It also talked about the juridical separation of Palestinians and Jewish settlers in the occupied Palestinian territory, who they said live under two different and very unequal legal systems that govern the two peoples. So at the end of the day, it then said, we find that Israel's legislation and measures constitute a breach of Article 3 of CERD. And to me, the only reasonable interpretation of this is that the court found both racial segregation and apartheid are occurring through Israel's policies and practices. So what does this mean concretely for what is to be done? There has been a voice rising among civil society actors concerned with human rights in Israel and Palestine over the last, say, 10 years to call for the reestablishment of the United Nations Special Committee Against Apartheid. I think we're going to see this call now become stronger. We may even see it appear in the resolution from the General Assembly sometime in the autumn, which winds up accepting the ruling and talking about specific steps to be taken. The other thing that I just want to raise and put on the agenda for everybody to think about, and this stems from what Ardi has said, is Article 25 of the Charter of the United Nations. What the decision of the advisory opinion of the International Court of Justice wound up detailing were the number of UN Security Council resolutions on annexation, on the illegality of the settlements, on the application of the Fourth Geneva Convention, all of which Israel has defied and refused to obey. Article 25 of the Charter of the United Nations says that all states have to obey all decisions of the Security Council. I think the question then becomes is Israel in defiance of its fundamental obligations as a member of the United Nations? It's only the Security Council has the ability to, if you like, expel a member, but the General Assembly does have the ability to put restrictions, such as unseating a state. And we may see that rising as long as Israel maintains its stance that its operations in the occupied Palestinian territories are perfectly legal, that these belong to them. There's going to be no Palestinian self-determination. As long as it continues to defy both UN Security Council resolutions and the direction and findings of this advisory opinion, this is going to become, I think, an increasingly pertinent and central question facing the General Assembly in the months to come and the years to come as to whether or not Article 25 is to be invoked against Israel. Thank you.
Thank you so much, both of you. There are so many threads to pick up on, but we do have one more speaker that is unfortunately not joining us in person, but has shared a pre-recorded message. Our final speaker for today is Shahd Hammouri. Dr. Hammouri is a lecturer in law at Kent University and is an advisor at Law for Palestine. She has a book forthcoming titled Corporate War Profiteering and International Law. Shahd today will address military sanctions and arms embargoes in light of the advisory opinion.
there live. I'm currently recording this from Melbourne Law School, where the timing is quite different. This is a historic moment that has laid to rest a lot of the legal indeterminacies that many would argue have been invoked by Israel in bad faith in the past years. Overall, the decision stresses the gravity, systematicity, prolonged and structural nature of the violations committed by the State of Israel. It also demonstrates that Israel has maintained a policy of denying its own international legal obligations. Notably, the analysis by the court focused on economic elements, such as Israel's lack of adherence to rules with relation to the exploitation of natural resources within the rules of usufruct. So, after finding the illegality of the Israeli occupation as a whole, what are the consequences that the court thought of in relation to third state obligations? So largely the court reiterated pre-existing UN General Assembly resolutions, which again should remind us of their importance. The court noted, and here I quote, that third states ought to refrain from economic dealings which may entrench Israel's unlawful presence in the territory, to take steps to prevent trade or investment relations that assist the maintenance of the illegal situation created by Israel in the occupied Palestinian territory, and not to render aid or assistance in maintaining the situation created by Israel's illegal presence in the occupied Palestinian territory. So, in response to the structural and systematic nature of the illegalities committed, came the court's imagination of state responsibility. So here, state responsibility ought to respond to the Israeli war economy as a whole, not just in parts of it. And this means that also, once we read these obligations, next to the duty to prevent genocide that comes out after the engagement of the Genocide Convention in the case of South Africa versus Israel, and the Human Rights Resolution 5528, as well as UN expert calls for an embargo, an arms embargo, we see that states have on a larger duty not to engage with the Israeli war economy. So when it comes to arms, for example, we reach the conclusion that state duties in this context extend beyond Article 6 of the Arms Trade Treaty, where the state has the duty not to authorize transfers if they know that they will be used in international human rights law violations. In this case, the ATT imagines a direct causality on some level. And you can see that some states have actually resorted to, and in practice, argumentative tactics where they would ask civil society actors for an almost impossible task of proving how each weapon supplied was used. Of course, this is very difficult in light of the absence of access to Gaza at the moment and Israel's intentional destruction of evidence. And here I'm referring to US state practice under the NSM 20. So, as I said again, what these obligations read in a harmonized reading of international law give us states have an active duty to assess and measure their own influence to affect the Israeli war economy and the sustenance of these grave violations. So states here have the duty to disrupt the supply chain feeding into the Israeli war economy. In other words, an energy embargo, including jet fuel that feeds into warplanes that are currently dropping bombs on people in Gaza, as well as a three-way embargo. And that means no selling, no buying, no transiting weapons or components of weapons. So So this sheds an even louder voice of skepticism over another argumentative tactic used here by Germany, where it created this odd differentiation between war weapons and other components. Of course, as asserted by numerous civil society actors, this differentiation serves to masquerade the extent of Germany's contribution to the sustenance of Israel's war economy and, of course, in fact, the continuation of the illegalities committed. It's important to note that these obligations override any security concerns. And here it's important to note that the court clearly distinguished that security concerns cannot be understood to override international legal obligations. So this reiterates the important facet in relation also to third states who always use, of course, in their own rationale, Israel's security concerns in the licensing of weapons. They also use regional and security agreements to justify the continuation of the licenses. And here, for example, I'm referring to the NATO agreement. So this is an opportunity to remind us that such agreements cannot override international legal obligations. And here we have a hint that the Netherlands is reluctant to stop its own supply of parts of F-16 and F-35 to the U.S. pool, U.S. administered pool of components that then feeds into Israel. We find that their reluctance comes from a prioritization of their NATO obligations. Of course, these obligations do indeed exist and extend to corporations which have a separate set of obligations that even if the state is not abiding by its international obligations, these corporations have the duty to abide by their international obligations. And notably, most recently, the Working Group on Business and Human Rights has sent letters of warning to some of the biggest arms producers in the world. And under international criminal law, it is not out of the question that corporations can be prosecuted for complicity in genocide. And of course, national jurisdictions offer a lot of ways which these policies can in the future be questioned. So moving forward, how do we take this decision forward in the next period in the next few months? First of all, on a local level, it is important to ensure transparency, as the active duty here to assess the state's role in the Israeli war economy starts with understanding what contribution that state has. So, and we've had, of course, a lot of problems with transparency, particularly, for example, in relation to Australia and Germany, which have refused to disclose a good part of their own licensing. And then a three-way embargo. Of course, as we know, states will be very reluctant to take these forward, and it lies on the shoulders of activists and lawyers to use the language given by the International Court of Justice to contest the arms and energy trade in internal courts as well as through activism. And as I said, a lot of the points of contention that could have been raised previously are now no longer arguable. So, and secondly, of course, as the decision clearly states, we need to take this to the UN General Assembly. And the UN General Assembly needs to imagine the modalities to bring about the end of the Israeli occupation. And indeed, as history has taught us, such efforts would need to start with an arms and an energy embargo. And here, for example, I'm referring to resolutions in 1963 in relation to South Africa's illegal occupation of Namibia. So On that note, and I believe I'm already over time, it indeed is a historical decision, but it is nothing in comparison to the pain and suffering and the complete failure of humanity to see the truth, as well as stop and protect a vulnerable and precarious population from irreparable damage. And yet we are at a crossroad that we haven't been at before, where at least the international legitimacy of the state of Israel is is completely questioned, and its true nature is now quite very obvious. It is now upon us to take this to states and to ensure that these obligations are indeed enacted, and to ensure that the language of international law takes its effect not just through state action, but also through street action. Thank you very much.
We are very grateful to Shahd for that intervention. I'm actually going to now turn back to Professor Ardi for a question, if you don't mind. So you spoke about the fact that the court has said that this withdrawal of Israel, this unlawful presence of Israel from the occupied territories has to come to an end as rapidly as possible without negotiation. And you also mentioned that the advisory opinion addresses customary international law questions and questions that have Hughes Cogan's character. Can you maybe shed a little bit light on the idea of self-determination and what it means in the Palestinian context? Because I believe that is kind of at the core of this discussion, but also at the broader Palestinian question. So if you can kind of place this decision in the larger self-determination conversation, that would be really, really useful.
Sure, thank you. One of the two of the great pillars upon which the court's determination that Israel's continued presence in the territory is unlawful, forgive me, is Israel's violation of the general prohibition on the acquisition of territory through the threat or use of force, basically the prohibition against territorial conquest. The court makes clear findings of fact that Israel is engaged in annexation of huge portions of the occupied Palestinian territory that render the whole of that territory, Israel's presence in it, unlawful as an expression by Israel illegally of its intent to annex de jure or de facto the whole of the occupied territory. That's the first pillar, territorial conquest. The second pillar is Israel's ongoing violation of the right of the Palestinian people to self-determination. And through all of these actions, territorial annexation, settlement by the occupying power of the territory, usurpation of natural resources, etc., the court determines that Israel is in violation of the right of self-determination of the Palestinian people. Now, self-determination is, according to the jurisprudence of the court, an obligation erga omnes. That is to say, all states have an interest in ensuring that the right of peoples to self-determination is recognized and realized, even where those states aren't themselves implicated in violating that right? So because it is a right erga omnes, the Palestinian people have the expectation, and third states have the obligation to help see them realize that right. And in this case, in relation to an occupying power that is in the occupied territory, unlawfully for 57 years and counting. So how might that translate into action on the ground? Well, it touches on what Shahd just mentioned in terms of the arms trade, and what I briefly mentioned earlier in terms of the consequences for third states flowing from the opinion not to render aid or assistance in any way, which would expressly or impliedly help the Israelis maintain their illegal presence in the territory. Third states may discharge it's unclear what the upper limit of how a third state will be able to discharge their obligation, what the upper limit is, or how they would discharge their obligation not to recognize or not to aid or assist. But one thing that they can do is recognize the state of Palestine, right, as an affirmation of the Palestinian people's right to self-determination. A recognition of a state is not a legal requirement of the recognizing state. It's something that has nothing to do with law as such. That is the act of recognition. That is a political act. But many states may feel more capable now that the advisory opinion has been issued, affirming that the right of the Palestinian people to self-determination has been violated, which gives rise to the consequence that Israel's presence in the territory is unlawful. They may feel more capable, more able politically to recognize the state of Palestine. Today, there are 149 such recognitions. There are more or less around 200, slightly more than 200 states on planet Earth. So you might see going forward increased numbers of bilateral recognitions by states of the state of Palestine as an affirmation of their obligation to ensure that they do not recognize as lawful Israel's continued presence in the territory. But more substantively, no human right, we know this from the Human Rights Committee, no human right in the wide array of human rights, economic, social, cultural, civil, and political, can exist or be fulfilled, so goes the mainstream thinking on this, which I adhere to, without the right of self-determination being respected. This is why, for instance, the right of self-determination is a common article in both the International Civil and Political Covenant and Economic, Social, and Cultural Rights Covenant of 1966. So self-determination rests at the heart of this case, but isn't its only heart. And inevitably, the bottom line is Israel's presence in the territory is unlawful because Israel is not Palestine. That is to say, Israel has no sovereign right in the occupied Palestinian territory. The Palestinian people do. They are sovereign in that territory. They have a state that exists juridically in that territory. We know that to be true legally. The only thing that is impeding it from exercising full sovereignty and complete sovereignty over their territory, their natural resources, and so forth, is the action of an aggressive occupying power, being Israel, there unlawfully. One last point, the majority decision, the majority opinion, spends quite a bit of time focusing on one aspect of self-determination, which is oftentimes overlooked. And that has to do with the right of the people to freely dispose of their natural wealth and resources. And so here you have references not only to immovable property like land, but also these resources that derive from the land. And it's very, very broad, and they will impact the bilateral relations of states who trade in these resources, who trade in, say, wine produced in settlement, Israeli settlements, right? It's all the result of the usurpation of the natural resources of the people of Palestine, or the cultural trade that is in cultural relations between institutions of state on the one hand in third states and Israel on the other. There's a great deal of cultural property that has been usurped by the occupying power over decades that belong to the Palestinian people. I give one example, the Dead Sea Scrolls is a perfect example, right? So what I'm trying to paint here is an understanding that self-determination covers a great deal of space and scope, but so too does this opinion, and appropriately so. And that's why it is so important for when we look at the third state obligations under the opinion and what it augurs for their relations with Israel going forward. One final point, which I jotted down, which has now just come to mind. I do think that going forward, one point of contention and focus is inevitably going to be on the ability of states, third states, to distinguish, in fact, between Israel and Israel in the occupied territory. What do I mean by that? Well, we know that the Security Council and the ICJ has said that all states have the obligation to distinguish in their bilateral relations with Israel between Israel on the one hand and the OPT on the other. But in fact, over time, the Israeli The Israeli hand has been submerged so much into the occupied territory that it is very difficult to determine where the occupied territory begins and where Israel ends. Take, for instance, banking, right? The whole Israeli banking system in Israel proper is embedded in the occupied Palestinian territory. And banks, Israeli banks, are engaged with third states all over the world. Those third states are going to have to, in their bilateral relations with Israel, determine where Israeli banking functions, processes, systems end in Israel and where they begin in the occupied territory, and where the Israelis are not forthcoming in helping set in their relations with these third states where one ends and one begins. Then the presumption for these third states has to be against Israel. And Israel will not be forthcoming in trying to demonstrate that there's a difference between the OPT and it. So this is going to touch on trade with Israel, banking with Israel proper, unless the Israelis can demonstrate that there is no connection between what they're doing at home and what they're doing abroad in the OPT. This is going to be the nexus between Israeli actions in Israel and Israeli actions in the OPT, and the differentiation point, that's going to be an issue of some controversy and some focus going forward.
Thank you so much. And that kind of then brings me to the question that I would like to ask Michael before I come back to a question for the both of you, since both of you are also academicians. Professor Michael, Ardi outlined the details of what is going to be a contentious question, which is the distinction between Israel proper, as he has called it, and the occupied territories, where the states now have a duty, and the UN, to not recognize this and not deal with this and not give it legitimacy. So, reflecting on perhaps the South African example from the past, what do you think are the possibilities for the Security Council, keeping aside the veto that we all will imagine comes from any action, and the General Assembly, when it comes to actually working on making these distinctions or trying to support this process of identifying what banks or what corporations are dealing in the occupied territories? Because there is a database that is supposed to look into the companies that exist and work with the occupied territories, but we know that the funding process internally has made sure that that database doesn't get updated as it must. So with this with this advisory opinion, how do we take forward? How do we, as a civil society, or how do states take forward this advisory opinion to bring back this conversation of making this distinction and actually making the whole system unfeasible to exist, like we did in the case of apartheid South Africa?
And this, your question goes to the heart of what has to be done. This occupation could not have lasted a day, let alone 57 years, without the fact, absent the fact that there has been no cost, no accountability placed on Israel. As long as Israel realizes that the world is not serious about enforcing any of the resolutions coming from the Human Rights Council, the General Assembly, and particularly from the Security Council, given the American diplomatic shield that it's offering to Israel, then Israel has no incentive to want to unwind or undo its occupation. The only way, as many Israeli liberals and progressives have said, the only way for Israel to take seriously what the world has been saying for decades now through these resolutions is to start imposing costs on Israel, that it makes it going increasingly more difficult for them to sustain their economy, to sustain their trade and investment, and to sustain their ability to travel freely throughout much of the world. Somebody once said, once Israelis begin to realize they wake up in the morning and have to get have to apply for a visa to travel to any European country, that will, for them, will be the aha moment when they begin to realize that the world is getting serious with respect to this, and then therefore attitudes will wind up changing. You're absolutely right. By the very nature of the United Nations, most of the enforcement powers of the United Nations rest with the Security Council. And there we have 15 members, 10 who are non-permanent 2-year elected members and 5 who are permanent members, each with a veto. And therefore, the ability of the United States to extend indefinitely its protection of Israel is the biggest single difficulty. In his very eloquent memoirs from 2012, the United Nations Security Council, former United Nations Security Council United Nations Secretary General Kofi Annan had said that the Security Council has been over decades paralyzed on the single most important urgent issue on the UN agenda and the longest lasting issue on the UN agenda, Israel and Palestine. And he said that primarily rests with the possessiveness of the United States to ensure that it alone winds up handling the issue of Israel-Palestine file. Interestingly, in the separate opinion of the president of the International Court of Justice that he issued 10 days ago to accompany the ruling, he said that the only way forward, and it was an indirect jab, I take it, at the United States, the only way forward is, number one, that all dealings with respect to Israel and Palestine initiated by the UN and the international community has to be based on international law. He didn't use the word realpolitik, that's my term, but he's saying that you have to be able to put realpolitik aside, because that's what's led us over the 30 years of the disaster that is the Oslo Accords. The other thing he said is this has to be done within the framework of the United Nations. And that is going to potentially set up a point of tension between the United Nations and the United States. I would suspect that if resolutions coming from the General Assembly, either this fall or in the years to come, particularly when there's no progress at all, no sign of all with respect to Israel taking any steps to unwind the occupation and to recognize Palestinian self-determination, that this is going to present an extraordinary tension point between the US and the UN. As long as the UN keeps on pushing for accountability and cost with respect to Israel, the US will resist. And there will be tension within the United Nations as to whether or not they want to fear the withdrawal of the United States with respect to its substantial funding of UN operations over the years. So that's my sense of how things may well be playing out. But I should also say I doubt very much if this is the last time that the General Assembly will be asking an advisory opinion of the International Court of Justice. If there is agenda items of things to do that arise out of UN General Assembly resolutions with respect to putting into action the ICJ opinion from 10 days ago, and they're not working, I suspect you might well see a new request for the UN General Assembly to ask another advisory opinion of the International Court of Justice as to what would be appropriate sanctions to place on a state that's a serial refuser to put into action directions coming from the UN. And that, I think, would be welcomed, because I think it's going to have to raise what's happened. We have rich experience, obviously, from what the UN did with respect to South Africa, both with respect to not recognizing the South African regime with respect to its seat at the General Assembly, but more importantly, what the world was forced to do, primarily coming from the third world, the global south, and coming from civil society, while placing sanctions on South Africa to raise the cost of continuing with apartheid and continuing with its illegal rule over Namibia. I think we have to think the same path is before us with respect to Israel and the United Nations.
Thank you so much. Professor Ardi, would you like to comment on something? Or okay, all right, then I bring in my next question, or based on what both of you have said. So we need to mobilize around the advisory opinion. The UN system with the Security Council veto powers has to be pushed to do what it needs to do, just like the states that have bilateral agreements and investment in in the continuation of the occupation. So a lot of this movement then comes from the streets, so as to say. So it comes from the civil society. It comes from people who are actually encountering these financial means in an everyday basis. It comes from student encampments, and that's why I refer to both of you being academics. This is kind of a sea change, or let's say an expansion of the seen with the Palestinian people in the last few months. Can you hear me?
No, Anisha, you've all of a sudden your voice has dropped down. So after sea change.
Give me a second. Is this any better?
I think what you're asking us, though, is in terms of what should be done, particularly from the perspective of what we see as academics, in terms of putting the ICJ decision into force, and where the, if you like, the intellectual arguments are going to be over the next little while. Ardi, let me invite you to address that first, and I'll pick it up.
Oh, wow. For a moment, I thought you were going to, but I'm happy to. Yes. From now on, the whole of the Palestine freedom movement's arguments concerning rights, international law, concerning racism, racial segregation and apartheid, concerning self-determination, concerning the illegality of the presence of Israel in the OPT, concerning even the falsehood of Israeli self-defense arguments as a justification of their maintenance of the occupation, all of that, all of those talking points have been affirmed. So for university administrators or local government or regional government or national government in domestic realms, the presumption is that what Israel does in the occupied Palestinian territory is itself unlawful. And that presumption is a big thing because that will help shape how argument is made, how policies are formed, and so on. So that is an extremely important thing going forward. For me, this is the reason why the opinion is a sea change. It's a structural change legally to how we understand what Israel is doing in occupied Palestine, notwithstanding the very important cases that exist at the ICJ on genocide and the other actions at the ICC and the potential issuance of arrest warrants. Those things in and of themselves don't address the structural issues here. And therefore, this case gives hope that there will be a greater opportunity for change going forward. Yeah, and civil society is absolutely vital. In fact, I think, as Michael said earlier, their role is going to be, they're going to have to be in the lead because states typically would act very, very slowly. States, in terms of being administrative units and political units, will be given to political pressures. Civil society won't face the same. So as an indication of what it is I'm talking about in terms of the impact of the advisory opinion or an advisory opinion, have a look at what took place in 2004. There you have a question put before the court on the legality or the legal consequences of Israel's construction in the OPT of the wall. The court rules that the wall itself is a violation of international law, and it's just focused on the wall and a few other subsidiary questions, self-determination, and so on. And merely 1 year after the issuance of that limited scope opinion, the international call for BDS emerged from Palestinian civil society, and it has had its gains made over a decade and a half, to the point where today, in the world of social media and knowledge transfer at the click of a button, the whole swaths of the world community are being swayed and educated about what's happening. This opinion is, in terms of its breadth and expanse, far broader than the 2004 advisory opinion, and it is a wind in the sails of the BDS movement, without a doubt. And civil society is going to play an extremely important role in keeping the pressure up, and as Michael said, forcing a cost on the aggressive power engaged in racial segregation and apartheid in the occupied Palestinian territory, such that we hope at some stage reason will prevail and they'll leave.
If I can just add to that, I think it's important not to be starry-eyed about international law and its ability to lead us to justice. In any domestic system and in any international system, there always is this inherent tension between law in the service of power and law in the service of justice. And that's what we've seen played out over the last 75 or 76 years with respect to Israel and Palestine. We continue to see that played out today, and will continue into the future. You know, it's important for all of us to be realistic and critical about international law's limitations, which have largely been imposed upon by powerful countries like the United States, and to a slightly lesser degree by Europe as well, with respect to Palestine. But having said that, and I think I'm echoing Ardi's sentiments as well on this, I think it'd be a huge mistake to be cynical about international law's possibilities. People everywhere respond very positively to when a particular issue or a concern is deemed to be unjust, and even more so deemed to be illegal. I think winning significant legal victories, particularly like we've won now at the International Court of Justice, is an important leads to and fuels important political campaigns. It gives those who have fought so hard for so long with respect to applying international law to Israel and Palestine new wind in their sails. It gives them new hope. It gives them new optimism. It gives them new energy to be able to respond to all this. And it brings new people into this, as we've seen through these student encampments everywhere in the world regarding protesting their universities' relationships with Israeli universities, or where their investments are with respect to either weapons companies that do trade with Israel, be it with Israeli links to Israeli universities. All of this, I think, are more and more bricks in the wall with respect to finally building the path towards justice, and the structure that's going to recognize justice instead of bowing down before power.
Thank you so much. I think this is a good moment to kind of end this conversation. Thank you for shedding light on what the opinion means, and also on its limitations, and how for outlining and articulating in detail how it is now upon the rest of us to make sure that we take this opinion forward and do with it what needs to be done, so that the Palestinian people can actually enjoy their right to self-determination and everything that comes from it. Thank you so much also for being so generous with your time. And I apologize one more time for the delay. And I hope that this is the first of many conversations that we have going forward, and understanding how we can use what we have gained legally for getting to justice. Thank you so much.
Thank you very much for having me.
And me. Thank you so much.
Thank you.
Be well.